Valdo Calocane. Are you Valdo Calocane? Please answer yes or raise your thumb. Calocane, can you hear us? Calocane.
Are the speakers working, Mr. Calocane? Could you please raise your hand? Can you hear us? Is there an officer in the room with Mr. Calocane?
Proceed, yes.
You happy, Andrew?
In any event, my solicitor, I think, is on the link, and he will be in touch with you later.
Good.
Anyway.
Good. Thank you.
That's correct. Solicitors are
Thank you very much indeed.
This is the reference by the Attorney General on Section 36 of the Criminal Justice Act 1988. You see the hands-down judgment.
Thank you. We are handing down our judgment in writing. The written judgment is accompanied by a written press summary. Both documents will be available at the end of this hearing. We will now deliver, thank you, a short oral summary of the reasons for and our decision. The oral summary does not form part of our judgment, nor is it in substitution for it. This reference by the Solicitor General concerns the sentence imposed on the offender, Valdo Calocane, on the 24th of January 2024 at Nottingham Crown Court for 3 counts of manslaughter by reason of diminished responsibility and 3 counts of attempted murder, to which offences the offender had earlier pleaded guilty. The judge, Mr. Justice Turner, sentenced the offender to a hospital and restrictions order pursuant to sections 37 and 41 of the Mental Health Act 1983 for each offence to run concurrently. The Solicitor General sought leave to refer these sentences to the Court of Appeal on the basis that they were unduly lenient. The factual background. On the night of the 12th of June and into the early hours of the 13th of June 2023, Valdo Calocane went out on the streets of Nottingham, having armed himself with knives. Shortly before 4 o'clock in the morning, he attacked and killed Barnaby Webber and Grace O'Malley Kumar, 2 young students walking home after a night out. Just over an hour later, he attacked a school caretaker, Ian Coates, who was on his way to work, killed him and stole his van. The offender then drove to the city centre, where he deliberately drove the van at speed into another man, Wayne Burkett, causing him serious brain injury. Minutes later, he deliberately drove into 2 other victims, Sharon Miller and Marcin Goronsky, also causing serious injury. These were random attacks. None of his 6 victims were known to the offender. The offences, understandably, caused shock and concern throughout the country and beyond, and unimaginable grief to the victims' families and friends. The offender is now 32 years old. He does not appear to have had mental health problems until 2019, and he had no previous convictions. The psychiatric experts agreed that the offender was suffering from treatment-resistant paranoid schizophrenia. His symptoms included persecutory delusional beliefs, hallucinations, thought alienation, and disturbed behaviour. The experts agreed that, had he not been experiencing symptoms of acute psychosis, he would not have perpetrated the acts. He was entirely driven by the psychotic process. all the medical experts agreed that a hospital order with restrictions was appropriate, and that a life sentence of imprisonment with a hospital and limitation order under Section 45A of the Mental Health Act 1983, known as a hybrid order, would not provide the public with the same level of public protection. The issue and the argument. The sole question for us was whether the sentences imposed are unduly lenient. This is a high hurdle. The court must ask whether the sentences fell outside the range of sentences which the judge, applying his mind to all the relevant factors, could reasonably consider appropriate. Whether, in other words, the judge below has fallen into gross error. The Solicitor General argues, 1, that the judge failed to reflect sufficiently the multiple aggravating features of the offending when arriving at an appropriate minimum term of imprisonment under a life sentence. Secondly, that the judge failed to take sufficient account, first, of evidence to the effect that the offender's culpability was not extinguished by his mental illness, and second, the extent of the harm caused. And thirdly, that the judge was wrong not to include a penal element in the sentence. It was submitted that the overall seriousness of the case required the imposition of a hybrid order. Our analysis. It is accepted by the Solicitor General that the judge made no error of principle in his approach, and that his choice was stark and binary, either hybrid orders or hospital and restrictions orders. The Solicitor General contends that the offender's criminality was aggravated by multiple features, including planning and the purchase of knives. However, the psychiatric evidence established that these actions were part of one psychotic episode of intense severity. The judge recognised that the offender's culpability was not extinguished, and that he had to consider whether a penal element was necessary. Because the offender's level of retained responsibility was low, and in circumstances where the offending would not have taken place but for the offender's schizophrenia, the judge was entitled to conclude that a penal element was unnecessary. This was so despite the number of victims and despite the extent of the harm caused. The schizophrenia was the sole identified cause of these crimes. So, for example, there was no evidence of substance abuse, no evidence of any culpable failure to take medication, or any motive for attacking these victims. The key factor in a case like this, when deciding whether or not a penal element is required, is the strength of the link between the offender's impairment and the offending in question. Here, at the time of the assaults, the offender was in the grip of a severe psychotic episode. The judge properly took into account the different regimes that would apply, depending on which of the two possible sentences was imposed. His conclusion that hospital orders with restrictions were appropriate was consistent with the principle that the graver the offence and the greater the risk to the public, the greater the emphasis that should be placed on the protection of the public. He reached the reasonable conclusion, based on the psychiatric evidence before him, that the aim of public protection would better be served by hospital with restrictions orders. In any event, the extreme violence perpetrated by the offender makes it very likely that, whichever of the two options had been adopted, the offender will spend the rest of his life in a secure hospital. Our conclusion. There was no error in the approach adopted by the judge. The sentences imposed were not arguably unduly lenient. Leave to refer the sentences is refused. It is impossible to read of the circumstances of this offending without the greatest possible sympathy for the victims of these terrible attacks and their families and their friends. The victim impact statements paint a graphic picture of the appalling effects of the offender's conduct. Had the offender not suffered the mental condition that he did, the sentencing judge would doubtless have been considering a whole life term of imprisonment. But neither the judge nor this court can ignore the medical evidence as to the offender's condition, which led to these dreadful events, or the threat to public safety which the offender continues to pose. Thank you very much.